Okay, abusuya be ma kwa ba sonko so edeba POG Media so. Abusuya yembonra eye yensem. Finally eye abrewa ayipuma ewo kwam. Abrewa akasa abusuya Chief Justice eye former Chief Justice eye friend Atuguba. Aba be clear no edin sembi to ja or chese processes na koso chese yede ba be remove eye Torkornoo ede free ne position no eye ne kwan so ano nti no sisi ano finally no eye Atuguba aba betru massive support to eye John Dramani Mahama say masa eye judicial system no ye hia eye John Dramani Mahama clear oji amanfo every match as a Chief Justice ne three petition na ye petition against her no former Chief Justice friend Atuguba no or say as a processes ne koso bibia ekoso ama lawyer Martin Pebu ababe edinensema say Atuguba kind or DB ababe to dry just nina go against Chief Justice Torkornoo abusuan sisi ade Chief Justice Torkornoo on a mana ordinary and actually ne time aso Atuguba so ababe yina ma enye asamke to Akroma amomi yanko na yankonko ti ensema so lawyer Martin Pebu the details wa ababe chire ensema echese ensema ababe chire no nyoma mu eda ho ansa ne bekono and some can be a share your comment section like share my Afro so answer into me and can be POG Media. So political trending stories are a make waves in the end so yeah to see any bebremo but I must say
taken away from the president if we truly want the judiciary to be independent indeed, not in words alone. Correct?
Absolutely, Mr. Kansi. Absolutely. Because we've all seen that for all the arguments that Professor Jampo is raised, we've actually seen that that's been our history, that is shown that some judges are not able to hold their independence, okay? Yes, once they get their appointment, then they seem to pander. Others have held it well, but look, if we are speaking bluntly, overall, we all know that generally the judges would, seem to defer to the presidents that appoint them. That's the overall picture. We are not saying that 100% that's what happens, but we mean generally. And Professor Atuguba once did a paper on it, and when he released it in Gimpa some years ago, it brought the judiciary to their feet. I remember Chief Justice Akuffo then, Yasantua, our beloved Yasantua, telling Professor Atuguba to be more nuanced, to put, salt. The phrase was to make sure that his statements were said that were nuanced and more acceptable, but not to make it so categorical that the judges tend to vote for the presidents that appoint them. Yes, Justice Duce also came in, but he was more measured. And then, so you see how far we've come. So Atuguba's paper is there. At least he has done a research paper. It's more rigorous than the anecdotal evidence that we are giving. But listen, nobody can fool me, and nobody can stop me from making the point that overall, generally, it goes when it comes to the matters, when it comes to the crunch. Let's separate the topics. There are those that generally go for a better society, like the cases that I've done, the people number 1, number 2, number 3, etc. Yes, those are not political. But we are talking about the hard cases. When it comes to the hard cases, it's politics. And let's not forget that even in the selection process, the presidents usually choose judges who share in their viewpoint, judges who share in their philosophy, judges who have their own, they share the same philosophy. That's it basically. That is what we usually say in common parlance, that this judge is NDC and that judge is MPP. That's what we say in common parlance. But if you want to put it intellectually, you would say that they share the same philosophies, the same vision, okay, the same ideology,
but
the
Martin,
same
not to cut you, but you see, Martin, you can share in the philosophy of the president without being a bootlicker, because we know elsewhere judges are appointed. Yes, no president want to appoint a judge who is openly opposed to him. But elsewhere, judges are appointed, and you have the judges asserting themselves. If the appointing authority is wrong, they will say that you appointed us, but this one you are wrong. And so it is good to have people appointed that who share your philosophy. But the point is that sharing a philosophy of appointing authority is not the same as being seen as a bootlicker and always doing the bidding of your appointing authority. If you do that, then constantly our judges would always be candidates for attempts at removal.
Well,
okay. Yes. Okay. Yes. So, and you see, this sometimes, look, let's go open. Sometimes we make it look like it's only in Ghana. Trust me. In the United States of America, when Trump won, before he won, what did he say? He said if he won, not the second term, the first term, that he was going to appoint justices to the Supreme Court who will vote for him to overturn Roe versus Wade. When we say Roe versus Wade, that's a Supreme Court decision in the U.S. that now bans abortion. There are certain exceptions. We cannot go in there. But generally, under Roe versus Wade, it was easier. Okay, the pregnancy was divided into three, the trimesters. First 3 months, second 3 months, third. It was generally easier first 3 months, second 3, and then more complicated in the third. Right. But overall, Roe versus Wade is generally gone. But the point we are making is that before Trump won, that was his promise to the people that, look, he will get judges who will come and overturn Roe versus Wade. And true, when he became president, Amy Goldman, the Catholic, the Catholic judge and other justices, he selected them well. They sat on it and boom, or if you like, boom, Roe versus Wade was gone. So it tells you that generally, it's something. It's not peculiar to Ghana. We are not saying it's good. Okay, no, that's not. But we're just saying that it's a human problem. And so far, we have shown that we are about to take the lead. We are about to make sure that the president doesn't appoint superior court justices and doesn't appoint the chief justice. So for Akuffo, he said it. She granted an interview. Before she granted it, we even had started. This is a conversation that has been going on. It's been over 10 years since this conversation started that in the new constitution, the president should not be appointing chief justices. We need a different judicial council that would not also have many of the president's appointees. The president will not appoint persons onto the judicial council. It will be independent. And it's that judicial council that will see to the appointment. So yes, we are moving towards there. It looks like JM is ready to give it. Everybody sees that JM is hungry to leave a legacy. It looks like he's hungrier than Kwame Nkrumah, it appears, because he wants to leave his mark on this country. And it's good. It's good we trolled him in opposition for 8 years. I think the trolling has finally, it got to him. And so that the next time I get an opportunity to lead Ghana, I'll be said that even Kwame Nkrumah will find it difficult to beat me. And so far, it looks like it. So even though we've not yet seen the work of the Constitutional Review Committee, it's very clear that generally the nation is moving towards an independent judiciary, at least in the form of appointment. Let's not forget, even when the president doesn't appoint the justices, there are other ways the president can control. You remember Chief Justice Torkornoo, the current Chief Justice, said it, that at a point, Akuffo was using money to control the judiciary. He would not release their budgetary allocations and thereby would be able to control them. So we'll still be then left with the financial independence. So perhaps the chairman of the Constitutional Review Commission, Professor Prempe, should be looking at that angle too. How we'll strengthen it. Yes, currently, on paper, they will tell you that, when the judiciary send their budget, you can't cut it and the rest. But practically, there are ways of going around it. So perhaps the committee should be looking at how they can get the financial independence too.
Actually, is that to say that with this injunction by that's Vincent Assefa and another at the Supreme Court, the expectation was that the president should halt the consultation with the Council of State on these petitions against the Chief Justice and asking for her removal?
It will, you see, legal jurisprudence helps the law so that in this situation where the actions of the president conjunctively with the Council of State, one is aggrieved by it, whether it is meritorious or not, out of which an application has been served. The jurisprudence behind it is that, just as I explained, in respect to this decision as reached by Akuffo J, it means that, you see, and you will transpose that to section 10 of the Criminal Offences Act at 29. We also look at Article 1912 of the 1992 Constitution. That deals with fair hearing and also issues of interfering with justice administration or matters before the court. Now, the whole reason is that, and just as I said, when the application is served on you, you have to allow the court to determine it. At the end of the day, you seeking to carry out with a particular step has to be run in juxtaposition to what the court would say. And in determination of what the court would say, if it should go contrary to whatever step that you are taking, it will not run in sync with it. Now, if you take further steps, it would also be deemed as, just as I said, usurping the powers of the court. And to allow for the balance of rights of whatever the aggrieved situation or issues are, natural justice, or fair trial, requires that allow the court to determine the application.
But I think, let's be fair, counsel. You see, relief one of Assefua's suit, and always remember that an injunction doesn't stand alone.
Yes.
There's a primary document, which is the writ.
Yes.
Then the injunction is predicated on it. Yeah. Relief one of Assefua's destiny is that, to the extent that President Mahama did not notify Madam, her ladyship, the Chief Justice, prior to the consultation with the council, it was unconstitutional. Relief one.
That's true.
Now the president had gone ahead, not only notified her, submitted the petition to her for her comment.
That's
so
okay.
The primary relief, hold on,
No.
The primary relief had effectively become what?
Moot. Nobody is arguing.
So the issue of holding the balance has been taken care of.
Yes.
And you see, if you read the decision you premise, my Lord Justice Akabwafo's decision,
yes.
You notice that he also gave a caveat that where the person is performing a constitutional duty, the court should be slow in clogging that constitutional duty with injunctions.
Okay.
In the same decision. So the judge then provides two scenarios. Oh, land, typical land issue. Oh, you are building on my land, there is litigation. Court can say, okay, hold on. Because you are building, stop. Let's get it done. But he said, look, once the person, and flowing from the decision in ex parte Ghana lotteries, he was fortified by that decision to say that once the person is performing a statutory or constitutional duty, the court should be slow in clogging that performance with injunctive orders, which finds expression in the decision that His Lordship Justice Akabwafo made. So he provided two scenarios. In this specific case, who else can receive a petition for the removal of a Chief Justice? The President. Who else will consult the Council of State? The President. So at this point, it is a duty that can only be performed by only him, not even the Vice President, not even the Speaker. So, Leonard, let's situate the conversation properly so that it doesn't look like the claim by Mr. Godfrey Adami. And for him, like I said, I didn't want to because I did e-levy with him. Immediately the president assented. They started a collection, even though we were in court.
Okay, so that's why...
I was in court that day with him, and he justified it.
So you say that
incidentally, hold on, incidentally, that panel, that e-levy panel, the leadership, the Chief Justice on it.
I see.
Yes.
So like
yes.
So based on the argument that you're making, to the extent that even there's precedence to what is happening now, the former President Akuffo was wrong to have assented to the e-levy, even though there was an injunction hearing ongoing or in place.
Yes, I mean, just as he said, you see, in the decision, the learned judge was even slow and cautious in making that particular decision. I mean, in response to issues of constitutional duties. You see, what is I love legal theory and jurisprudence a lot because what is the philosophy of the law? At the end of the day, in the situation we positing it in rule of law and looking at achieving justice at the end the end goal is to achieve justice. Now, there is an ongoing process under Article 146. And with that process, Article 146 has been invoked. However meritorious or unmeritorious that particular application is, we all agree that that application has been rendered moot because the president has afforded her leadership the opportunity to respond. Now, for jurisprudence sake, what would it be for the president to allow that particular application to be heard in order to ensure that, yes, rule of law has been upheld, and for whatever it is, even though in the Akabuafo decision, there was a caution by the courts to hasten slowly in dealing with constitutional matters. The decision did not serve as a bar, but it only indicated that when it comes to that, let's hasten slowly as to what the situation would be, or for further decisions to come, whether from the High Court or especially from the Supreme Court, to authoritatively declare on how matters involving constitutional matters should be dealt with. The situation would keep evolving. Now, in the milieu we find ourselves, one would say, or legal scholars would be split into two schools of thought of should we allow or should we say that where constitutional matters are involved in an injunction application is served, should the constitutional duties carry on, or there's a caution by a judge, by a learned judge who indicated that yes, the constitutional duty is important because it is in respect of state duty. So let's hasten slowly. How do we deal with it? So these are matters of constitutional jurisprudence, and a clear decision ought to be taken to deal with such matters.
Because then anybody else will just go to court. And you see, for example,
I want to understand so that I can contribute.
So it's okay. Because you've made your point, I want to understand
because
it's okay.
Let me receive some. Let me just exposition on this matter. Bring some clarity. But when I listen to him, I get
allow me to just stay on the course on this matter. So, what exactly has President Mahama done wrong exactly in this instance?
No, so in simple terms, an application for an injunction, simpliciter, when served on you, you have to restrain yourself. That is the legal thinking behind it. You have to restrain yourself from taking further steps until the matter is determined.
Despite what the judge,
That's why I said,
you know,
I am building a point. I said, an application for injunction simpliciter, when it is served on you, you have to restrain yourself, whether or not the matter is heard or not. So,
okay, abusuya we ne ensema ekoso our political highway. So lawyer Martin Pebu and I say ode eye ensem no to an better masse say moje penekoko tisa odi we edemai aha POG Media so better masse.